The reason to remand is because the lower court hasn't addressed any question of remedy, and so in the first instance you should send it back to the lower court for a full adversarial briefing subject to
but
waiver and all
North
the
Carolina
rest.
has a rule, I thought, that if you violate the Fourth Amendment, that's it. We don't have a good faith exception.
That will be our position on remand, Justice Ginsburg. The state may try to persuade the court of something else.
Isn't that what the North Carolina law is now? So it would be futile to send it back for them to answer the good faith exception since they have none.
It wouldn't be futile, Justice Ginsburg. I think the analogy that I gave earlier about Chapman is more or less on point. The Court has held that if the Constitution is violated, that the defendant in a criminal case doesn't get a remedy unless he satisfies that test. Now, all the time in criminal cases, you would just decide the constitutional issue and then send it back for remedy analysis if the lower court hadn't addressed it.
That's because they would be applying federal law. They would be answering the question that you want us to leave unanswered, namely whether the Constitution requires that this evidence be stricken from the case.
Well, let me say.
But if indeed they're not going to ask that question when we send it back, it seems to me we have to answer that question here before we are able to reverse or affirm the North Carolina court. It's a federal question. They are not going to get to that. But you're asking us to invalidate this conviction on the basis of federal law. And it seems to me we cannot do that unless there has if there has been a violation of the Fourth Amendment, the remedy must be exclusion of the evidence. That's a federal question. I think we're going to have to decide it. If we send it back to North Carolina, they're not going to decide it.